Hello, I'm Melanie Tezzer and I work for the Legal Aid Agency and I'm based in the Liverpool office. I work in civil finance and have been with the agency for over a decade now. Up until very recently, I was a civil finance caseworker, generally processing housing claims, JR claims, but for the most part, I processed appeals. But as I said, I've recently become a supervisor, so I'm a little bit more hands off, but I still do keep my hands in. So a brief introduction to appeals. The appeals teams are spread across various legal aid offices. Escape cases appeals are processed by caseworkers in both Liverpool and South Tyneside, with the National Appeals Lead being based in the Liverpool office. Appeals are allocated to the relevant teams within specialist areas such as civil finance, mental health, escape cases and high cost cases. Appeals caseworkers are also assessors, so they will be familiar and up to date with guidance and will have the necessary skills to make reasonable decisions on the information you have provided in support of your appeal. Each appeal is logged on receipt on an internal tracker. The appeals caseworker will determine to either reject the appeal, grant the appeal, request further information, or refer the appeal on to the independent cost assessor. And I'll pass you to Steph.
Hi everybody, my name's Stephanie Roper and I'm a senior caseworker on the Escape Cases team based in Liverpool. I've been on the Escape Cases team since 2008, which is when it started. Been with Legal Aid since 2006. I personally process the mental health escape cases and appeals and the immigration and asylum escape cases and appeals. I also do quality control. I've been doing some training and mentoring, and also some CW3 applications as well. So as Mel said, I'm going to discuss now what the independent cost assessors are and when they are used. So any appeals that we receive in which the internal reviewer cannot make a determination on are then referred to an independent cost assessor, or ICA for short. ICAs are providers who have a contract with the legal aid agency and they practice in the relevant area of law that they are being asked to consider. So for example, a mental health escape case appeal will go to a mental health provider. The ICA work independently of the LAA. Their decisions are not influenced by our teams. We will provide them with your appeal evidence and an agenda note which we draft, which will list what issues remain in dispute. And the ICA decision is final. There is no further right of appeal once an ICA decision has been made. And I will pass you back to Mel.
Hi. Now I'll go through the appeal contract rules. They state that you have the right to appeal against our assessment findings on all claims that are billed to the LAA, pursuant to the Standard Civil Contract 2018. 6.71. If you or counsel are dissatisfied with any decision of ours as to the assessment of the costs of contract work, you may appeal to an independent cost assessor, the assessor. 6.72. The appeal must be made in writing, setting out full reasons within 28 days of notification of the assessment decision and must be accompanied by the file. We will only extend that 28-day time limit where you've requested an extension for good reason within 21 days. Any extension of time will be for a maximum of a further 14 days. 6.73 confirms failure to comply with any of the requirements set out in paragraph 6.72 means that you accept our decision and you then lose the right to dispute it. And I will now pass you back to Steph.
Thanks, Mel. So I'm going to discuss now what information is required for escape case appeals. So for all escape case appeals, we will require your EC Claim 1 form, a copy of your cost ledger, and a letter of representations, and this needs to confirm what reductions you are appealing and also why you are appealing them. So previously we have had appeal letters. If we've made reductions on a certain item, the representations will just say, please see original file note, but it doesn't actually specify what it is about our assessment that you disagree with. So we would remind you that if you do submit a letter of representations, if you can make it really clear what items that you are appealing and also why is it you disagree with our original decision. Where applicable, we will also require the following to be submitted with your appeal. So file notes for all items of work which have been reduced. And if any disbursements have been reduced, we will also need a copy of the disbursement vouchers. If your case was reduced to nil on assessment, then we would also recommend you submit your full file of papers. This is because pursuant to Standard Civil Contract Rule 6.80, if your appeal is successful, we will then need to assess your case. So if you submit your file of papers with your nil assessment appeal, it just means if the costs are reinstated, we can then carry out that assessment on the same day as well, and we can get the case closed off a lot quicker. If you are appealing a nil assessment, you will need to submit your fully completed means form and also evidence of means from the computation period. However, we do understand for certain benefits, we will accept letters that are within 6 months. And I will pass you back to Mel.
Hello again. Thanks, Steph. The information required for civil finance appeals. We do require written representations, so you can upload those as a document or send them via document request to us. We'd require copies of file notes and or explanation of work undertaken where those items are under dispute. Similarly, if it's a disbursement voucher, we'd ask you to upload that and any associated orders where applicable. A copy of the original claim narrative is usually very helpful, and also ledgers. Also, any document letter which supports your appeal. Just as an example here, we'd say if it was a GP medical report that was under dispute, a copy of that report would be beneficial. And if, for instance, it's to do with reductions with briefs, wherever possible, enclose a copy of that brief or indexes to bundle to give us an indication of the size of that bundle. And I will pass you back to Steph.
Thanks,
you.
Mel. So I would like to take some time to discuss the different stages of appeal. So you have the right of appeal against our assessment findings on all claims that are billed to the legal aid agency. So there are 2 stages of appeal. The first one is an internal review. Now this is where the appeal is considered by a new caseworker, so it's not the original assessor. The reason we do this is so there's fresh eyes that are looking at both the original assessments and the file and the representations. The second stage is when the appeal is referred to an independent cost assessor or ICA. So on internal review, the internal reviewer will review the original decision and consider your representations. If your representations are accepted in full, then the appeal process will end there. The reviewer will write to you advising of any changes made to the original decision and also your recalculated results. What we will also do as well, if we find that there's been a caseworker error during the assessment, we will also feed that back to the caseworker. We obviously do make mistakes on assessment, but we do take them very seriously. If we find there has been an error, the caseworker will be fed back to. If we do find there's repeated errors with a particular caseworker or in a particular area of work, that will highlight to us there could be potential training need or maybe further guidance needs to be sent around. So I wanted to reassure you that any errors that are identified, they are taken seriously. If your appeal is not accepted in full, then the issues remaining under dispute are referred to an ICA for determination. So what can happen is that we may have 5 items were assessed on the original assessment. They've been appealed and say the internal reviewer has accepted representations on 3 of those items and they've been reinstated. The remaining 2 items in dispute are then referred to an independent cost assessor. So they don't look at the whole appeal. It's literally only the items that will remain in dispute that they will have a look at. So what happens when your case goes to an ICA? All appeals are considered on paper and the ICA will consider the original assessment along with your letter of appeal, and they will consider the issues that remain in dispute along with the relevant contract rules and cost assessment guidance. They will then make decisions only on the matters that remain in dispute. We will forward you the ICA's determination on the appeal along with any revised impact upon the assessment. We do aim to write to you with the ICA decision within 2 days of receiving it. And we aim to have all appeals finalised within 20 days. So that's from the day we receive your appeal until the day you get your final decision, whether that be an internal reviewer's decision or the ICA's decision. And I will pass you back to Mel. Thank you.
Thanks, Steph. I'm going to talk about now what can and cannot be appealed. So scope can be appealed in some circumstances. So any work claimed within your bill which predates the issue of certificate cannot be claimed, but there will be an exception made in circumstances there has been an administrative error. For example, a typographic error on dates or wrong date submitted for outcomes discharge of the certificate. But I will add there that if it is down to a discharge of the certificate being incorrectly inputted, you need to get that corrected before you submit the appeal because it probably will be rejected. We recognise at times work is nil assessed which relates to billing, outcomes, final letters to clients. These can be appealed. Any items, disbursements reduced or nil assessed can be appealed, including reductions on disbursements where there is no codified rate. What cannot be appealed? JR Regulation 5A cannot be appealed. If permission is refused for JR, we cannot deal with the appeal. This ought to be done via the Judicial Review Discretion Proforma, which can be found at the gov.uk website. Codified rates cannot be appealed. We cannot increase codified rates and IACA has no right to do so. For example, expert hourly rates, which may be a psychologist process server. We cannot increase the rates payable for anything which has a codified rate. If you know that your claim is going to exceed this, submit a prior authority request. Appeals will not be dealt with on paper. And I will pass you back to Steph. Thank you.
Thanks, Mel. So I'm going to take some time now to discuss reasons for rejected escape case appeals. So over the last 12 months, 8% of all escape case appeals were actually rejected. 45% of the rejects were because the appeal deadline had expired and no appeal extension had been sought. So if an appeal extension has been given, it's always best to refer to this in your letter of appeal or your covering letter or your email. And if you can provide a copy of the extension confirmation as well, it's just to avoid any unnecessary rejects of your case. Please ensure all appeals are submitted within 28 days of the assessment. Any extension must be requested within 21 days of the assessment. On the escape cases team, our decision letters actually confirm the appeal deadline. However, if this information hasn't been provided, it's 28 days from the date on the letter. Now, 48% of appeal rejects is where the appeal is incomplete, and so we can't consider it. So this is usually where we have a letter of appeal, but no file note or other evidence has been provided in support of the appeal. So it's really important if you do submit an appeal against an assessment, if you can just spend a little extra time just to make sure that any items you are appealing, you have provided the corresponding file evidence. Otherwise, there's nothing we can do with that appeal. We will have to reject it back for you to clarify what the situation is. Now, over the last 12 months, the escape cases team have received 2,562 appeals. So we just want to focus on the three main reasons for appeals. So the first is that 27% of appeals are due to insufficient evidence. 88% of these appeals are then allowed on internal review. So this is where the file note provided doesn't contain enough information to justify the time claimed. So, for example, you could have an asylum case and you're claiming 4 hours to consider the client's previous Home Office file. The file note itself doesn't tell us how many pages were in that file. There's no actual handwritten notes, so we can see the information you've taken from that file, or copies of the file haven't been provided. So obviously on assessment, we can't judge if that 4 hours is reasonable because we have no evidence to corroborate it against. And then obviously on appeal, it is then submitted and we can then see then the work is justified and it will be reinstated. So 17% of appeals are due to insufficient evidence of means. 76% of these are allowed on internal review. So this is where the evidence provided doesn't demonstrate the client is financially eligible for legal aid. So for example, we could have a client who's been passported because they're in receipt of employment support allowance, and a bank statement's been provided that confirms ESA has been paid, but that doesn't tell us if it's income-based or contribution-based. So therefore, on assessment, we would make a nil assessment because we can't verify if the client is passported or not. And then obviously on appeal, that information is then provided and then we can reinstate the costs. Another issue we see quite often with asylum cases is where the client is being supported by family or friends, and they've mentioned, oh, I receive money from my family, from my friends, but the amount hasn't actually been specified and it hasn't been recorded in the means form. Again, we would have to do a nil assessment because we can't verify the client is eligible, and then that information is provided on appeal, which means then we can reinstate the costs. And 13% of appeals is due to being no evidence of time claimed. 89% of these appeals are allowed on an internal review. And this is literally where we can see on the ledger you've claimed time for preparation, attendance, but there's absolutely no file note has been submitted. So therefore, we've taken it off on assessment. It gets reinstated on review when the file note has been provided on appeal. So we wanted to discuss these numbers because it does illustrate the majority of appeals we process could be prevented if the necessary information was provided on assessment. So speaking of that, we'd like to remind you for all escape case submissions, we do require disbursement vouchers for all disbursements over £20. Any item of work for over 60 minutes or 10 units, we will need the file note for that item of work. A fully completed means form and evidence of means from the computation period needs to be provided. And as I said earlier, we know for benefit payments, we can accept notification letters, providing they're within 6 months of the date of the form, and that they specify the benefit type as well. Where applicable, we also need counsel's fee note. And we'd also ask that if there are any case complexities which have resulted in higher claims for preparation or longer attendances than we would normally see, if you can just explain those briefly on the file. So cost assessment guidance 2.12 suggests 2 minutes reading time per page of documentation, but obviously we have discretion to allow more where appropriate and where evidenced. Cost assessment guidance 2.15 suggests allowing 6 to 12 minutes to draft a page of documentation. But obviously there could have been difficulties on that file that have meant that those times have been exceeded. So for example, if you have like a mental health case and you've been reading the client's medical records, if they were handwritten, then we understand it would take a lot longer to read through those notes and to decipher what's been said and to extract the information. But if that hasn't been made clear to us on assessment, then we wouldn't know why the time is a little bit higher than normal, and that could then lead to a reduction. So we wouldn't need reams and reams of information. But if you did have an example like that, if you could just put literally in the file note, we were looking at handwritten notes, who are pretty illegible. It took a lot longer than normal for us to be able to read through them. It gives us then context of the case, and we can see why the times are a little bit higher than what we would normally see. If you are claiming time for considering documents, then pursuant to Cost Assessment Guidance 2.11, we will either need a copy of the documents to be provided on assessment or full details of the type of documents concerned and the number of pages involved. So again, we know some of the documentation can be very large in these cases, and it may not always be practical to either to scan those in and submit them with your case. So if you did have quite a large bundle of documentation, if you put in your file notes, so you'd spent 2 hours considering the client's most recent records. There was 150 pages that we needed to look at. We can then see if the time claimed is reasonable because we have the information to check that against. And I will hand you back to Mel.
Thank you, Steph. Now I'll touch upon civil billing and reasons appeals are rejected and hints and tips on how to avoid. 19.8% of all appeals received from January 2023 to the end of the year were rejected. This was a total of 396 appeals. 233 were rejected as submitted for the incorrect value. This is where your appeal value has exceeded the amount reduced from the bill. So just as an example, if your claim was submitted at 1,500 and we reduced it to 1,100, your appeal should only ever be for the missing amount, which would be in that case £400. 48 were rejected due to scope, those of which could not be appealed. And 58 appeals were rejected as submitted out of time. In the past 12 months, civil billing have received 1,891 appeals. 58% of these were granted on internal review. And the top reasons were disbursements being excessive. 66% of these were granted at stage 1 when evidence was submitted. Disbursements with no invoices. 87% of these were granted at stage 1 when the evidence was submitted. Enhancement excessive. 21% granted at stage 1 when the evidence is submitted. Preparation excessive, 47% granted at stage 1 when evidence submitted. Scope, incorrect dates, discharge dates, typographic errors, 71% granted at stage 1 when the evidence is submitted. So it kind of exemplifies that the evidence is really, really important here. To minimise the need for your firm to appeal any assessment, we advise supply additional evidence to support disbursements. Always include the associated orders. Submit detailed grounds for enhancement which are specific to the case. Quite often we will just have what appears to be cut and paste of the guidance within the grounds and reasons, which really doesn't give us a lot to go off. Upload file notes for preparation which exceed the 1 hour, or input the justification within the case narrative, for example, the page numbers, documents considered, why, for instance, an LA application took longer than usual. Always ensure your discharge date is correctly entered on CCMS.